Question 1. A notary public in North Carolina is asked to notarize a document for a signer who is physically unable to sign their name. The signer wishes to direct another individual to sign on their behalf. What is this notarial act called? A. Acknowledgement by a representative. B. Verification on oath or affirmation. C. Signature by proxy. D. Attestation of a true copy. Answer: C. Signature by proxy. A signature by proxy is the correct term for when a principal directs another person, the proxy, to sign the principal's name on a document in their presence. The notary must ensure the principal is competent and gives clear direction, and both the principal and the proxy must be physically present before the notary. For example, if an elderly person with severe arthritis cannot hold a pen, they can verbally instruct their adult child to sign for them in front of the notary. Remember that for this act, the proxy signs the principal's name, not their own. Question 2. A North Carolina notary's commission expires on June 15, 2025. What is the earliest the notary may apply for recommissioning? A. 30 days before expiration. B. 60 days before expiration. C. 90 days before expiration. D. 10 weeks before expiration. Answer: D. 10 weeks before expiration. North Carolina law permits a notary to apply for recommissioning up to 10 weeks prior to their commission's expiration date. Applying early ensures there is no lapse in the notary's authority to perform notarial acts, as it allows sufficient time for the Secretary of State's office to process the application. For instance, if your commission ends in mid-June, you can start the renewal process in early April. A good rule of thumb is to mark your calendar for 10 weeks before your expiration date to begin the recommissioning process without any last-minute rush. Question 3. What is the maximum fee a North Carolina notary may charge for taking an acknowledgement or a verification on oath or affirmation? A. $5 per principal signature. B. $10 per principal signature. C. $15 per document. D. A reasonable fee agreed upon with the signer. Answer: B. $10 per principal signature. The maximum fee allowed by North Carolina statute for most common notarial acts, including taking an acknowledgement or administering an oath for a verification, is $10 for each principal signature. This means if a document has two signers and the notary takes an acknowledgement from each, the total allowable fee would be $20. Always remember to inform the signer of your fees beforehand to maintain transparency and avoid disputes. Question 4. A notary is presented with a document that has several blank spaces in the main body of the text. The signer states they will fill in the missing information later. The notary should: A. Proceed with the notarization as requested. B. Refuse to notarize until the document is complete. C. Fill in the blanks with "not applicable" and then notarize. D. Advise the signer on what information to put in the blanks. Answer: B. Refuse to notarize until the document is complete. A notary must refuse to notarize a document that contains blank spaces or is otherwise incomplete, as this creates a significant risk of fraud. The signer must fill in all blanks or line through any unused spaces before the notarization can be performed, ensuring the document is in its final form. For example, if a car title has the buyer's name or sale price left blank, the notary must decline the act until that information is entered. A key part of your duty is to prevent fraud, and notarizing an incomplete document makes it vulnerable to later alteration. Question 5. Which of the following is a key requirement for a notary's official seal in North Carolina? A. The seal must be circular in shape. B. The seal must include the notary's commission expiration date. C. The seal must contain the Great Seal of the State of North Carolina. D. The seal must be rectangular in shape. Answer: A. The seal must be circular in shape. North Carolina law mandates that a notary's official seal must have a circular shape with an outer border, and the seal's diameter cannot exceed 2 inches. While the seal must include the notary's name as commissioned and the words Notary Public and North Carolina, or NC, it is the notarial certificate, not the seal itself, that must contain the commission expiration date. Think of the seal as your official brand. Its circular shape is a non-negotiable part of that brand's legal design in North Carolina. Question 6. A North Carolina notary moves from Mecklenburg County to Wake County. The notary must notify the Secretary of State of this address change within how many days? A. 10 days. B. 30 days. C. 45 days. D. 60 days. Answer: C. 45 days. A notary is required to provide written notice to the North Carolina Secretary of State within 45 days of any change to their residence, business, or mailing address. This ensures the Secretary of State has current contact information and that the notary's commission records are accurate. Failing to provide timely notification is a violation of notary law and can result in disciplinary action. The easiest way to handle this is to make updating the Secretary of State part of your moving checklist, just like changing your address with the post office. Question 7. What is the primary purpose of an Acknowledgement Notarial Act? A. To certify that the signer personally appeared and swore the contents of the document are true. B. To certify that the signer personally appeared and admitted to willingly signing the document for its stated purposes. C. To certify that the document is a true and correct copy of an original document. D. To certify the identity of a witness to the signing of the document. Answer: B. To certify that the signer personally appeared and admitted to willingly signing the document for its stated purposes. The core function of an acknowledgement is for a notary to confirm that a signer, who has already signed a document or signs in the notary's presence, appeared before the notary and declared they executed the document voluntarily. The key element is the signer's acknowledgement or admission of their free will in signing, not swearing to the document's truthfulness, which is the purpose of a jurat. For example, when someone signs a deed, the acknowledgement proves they weren't forced to sign away their property. Remember, for an acknowledgement, the signer doesn't have to sign in your presence, but they must appear before you to acknowledge their signature. Question 8. A North Carolina notary is also a real estate agent. The notary is handling a transaction in which they will earn a commission. The notary may not notarize documents for this transaction because it constitutes A. The unauthorized practice of law. B. A conflict of interest. C. An official misrepresentation. D. A breach of confidentiality. Answer: B. A conflict of interest. A notary has a disqualifying conflict of interest if they have a direct financial or beneficial interest in the transaction, beyond the notary fee itself. In this scenario, earning a real estate commission makes the notary a party to the transaction, which compromises their required impartiality. Notarizing signatures on documents for a deal where you are also the agent would invalidate the notarization and could lead to legal challenges. Always remember that as a notary, your role is to be a neutral, third-party witness, not a participant with a financial stake in the outcome. Question 9. A person who has been convicted of a felony in any state has applied to become a notary in North Carolina. Under what condition may this person be commissioned? A. They cannot be commissioned under any circumstances. B. Only if the conviction was for a nonviolent felony. C. Only if their full rights of citizenship have been restored. D. Only if they receive a special waiver from the county clerk. Answer: C. Only if their full rights of citizenship have been restored. North Carolina law prohibits anyone convicted of a felony from becoming a notary unless their full rights of citizenship have been restored. The restoration of these rights is a formal legal process that occurs after the completion of a sentence, including any probation or parole. This requirement ensures that individuals holding the public office of notary public possess good moral character and respect for the law. Think of it as a clean slate requirement, the state needs to see that a past serious offense has been legally and fully resolved before granting a position of public trust. Question 10. When a signer uses a signature by mark, such as an X, what must the North Carolina notary ensure happens? A. The mark must be notarized with a jurat instead of an acknowledgement. B. The mark must be made in the presence of two witnesses who also sign the document. C. The notary must write the person's name near the mark and the names of the witnesses. D. The signer must provide a doctor's note verifying their inability to sign. Answer: C. The notary must write the person's name near the mark and the names of the witnesses. For a signature by mark to be valid for notarization in North Carolina, the notary must write the name of the person making the mark near that mark on the document. Additionally, the names of the two witnesses who observed the marking must also be written near the mark. This procedure provides clear evidence of who made the mark and who witnessed it, safeguarding the integrity of the signature. Remember, your role is to create a clear record, so you must write the signer's name and the witnesses' names on the document itself. Question 11. What information must be included in the venue portion of a notarial certificate? A. The signer's county of residence. B. The state and county where the notarization is taking place. C. The notary's county of commission. D. The full address where the notarization occurred. Answer: B. The state and county where the notarization is taking place. The venue is a required element of a notarial certificate that establishes the geographical location where the notarial act was performed. It consists of the state and the county where the signer personally appeared before the notary. For example, if you are commissioned in Wake County but perform a notarization for a signer while you are both in Durham County, the venue must state North Carolina and Durham County. An easy way to remember this is that the venue answers the question, where did this happen? Question 12. If a notary's official seal is lost or stolen, what is the first action the notary must take? A. Order a new seal immediately. B. Resign their commission. C. Notify the Register of Deeds in their county of commission. D. Deliver written notice of the loss or theft to the Secretary of State. Answer: D. Deliver written notice of the loss or theft to the Secretary of State. The first and most critical step upon discovering a lost or stolen seal is to immediately notify the Secretary of State in writing. This official notification helps prevent fraudulent use of the seal and protects the notary from liability for any improper acts committed with it. While ordering a new seal is a necessary next step, the immediate official report is the priority to secure the integrity of the notarial office. Think of it like losing a credit card. You call the bank first to report it lost or stolen before you order a replacement. Question 13. A North Carolina notary is asked by a friend to explain the legal implications of a power of attorney document before notarizing it. How should the notary respond? A. Provide a general overview of what the document typically does. B. Explain the document's effects but advise the friend to consult a lawyer for specifics. C. Refuse to offer any explanation and state that doing so is the unauthorized practice of law. D. Read the document aloud to the friend without offering any interpretation. Answer: C. Refuse to offer any explanation and state that doing so is the unauthorized practice of law. A non-attorney notary must never explain, interpret, or give advice about the legal effects of a document, as this constitutes the unauthorized practice of law, UPL. The notary's role is strictly limited to performing the notarial act, which involves identifying the signer and witnessing the signature or oath. Even offering a general overview can cross the line into giving legal advice, so the safest and most proper response is to decline and suggest the signer consult an attorney. Your job is to notarize, not to advise. Question 14. A signer appears before a notary with a valid, unexpired government-issued photo ID, but the physical description on the ID, e.g., height, weight, no longer matches the signer's current appearance. The notary should: A. Refuse the notarization due to the discrepancy. B. Proceed with the notarization if the photo and signature reasonably match the signer. C. Ask for a second form of identification without a physical description. D. Make a note of the discrepancy in the notary journal and proceed. Answer: B. Proceed with the notarization if the photo and signature reasonably match the signer. The primary purpose of the ID is to ensure the person standing before you is the person named in the document, which is mainly achieved by comparing the photograph and signature. Physical characteristics like height and weight can change over time and are considered secondary identifiers. As long as the notary is satisfied that the photograph on the ID is that of the signer and the signature is consistent, the notarization may proceed. Think of it this way: the photo and name are the most critical links, and as long as those are solid, minor descriptive changes are acceptable. Question 15. The term of a North Carolina notary public commission is A. 2 years. B. 4 years. C. 5 years. D. 10 years. Answer: C. 5 years. In North Carolina, a notary public is commissioned for a term of 5 years, beginning on the date they are sworn in by the Register of Deeds. At the end of the 5-year period, the commission expires, and the individual must apply for recommissioning to continue performing notarial acts. This 5-year term is a foundational piece of knowledge for any NC notary. A simple tip is to remember the number 5 is key to your commission's lifespan. Question 16. What is the main difference between an acknowledgement and a jurat, also known as a verification on oath or affirmation? A. A jurat requires the signer to sign in the notary's presence, while an acknowledgement does not. B. An acknowledgement requires an oath, while a jurat requires an affirmation. C. A jurat can only be performed on financial documents. D. An acknowledgement requires 2 witnesses, while a jurat only requires the notary. Answer: A. A jurat requires the signer to sign in the notary's presence, while an acknowledgement does not. The critical distinction between these 2 acts lies in the signing and the verbal ceremony. For a jurat, the signer must swear or affirm that the contents of the document are true and must sign the document in the physical presence of the notary. For an acknowledgement, the signer simply appears before the notary and states that the signature already on the document is their own and was made willingly, meaning they don't have to sign in front of the notary. Remember, jurat sounds like jury, where you swear to the truth, and that swearing and signing must happen right in front of the notary. Question 17. A notary is asked to notarize a signature on a document written entirely in a language the notary does not understand. What should the notary do? A. Refuse the notarization because they cannot read the document. B. Proceed with the notarization as long as the notarial certificate is in English. C. Find a certified translator to explain the document before proceeding. D. Ask the signer to provide a written summary of the document's purpose in English. Answer: B. Proceed with the notarization as long as the notarial certificate is in English. A notary is not responsible for the content of the document being notarized and is not required to understand the language in which it is written. The notary's duty is to properly identify the signer and complete the notarial certificate, which must be in a language the notary can read and understand, typically English. As long as the notary can communicate with the signer to perform the notarial ceremony, e.g., taking the acknowledgement or administering the oath, the act can be completed. Your focus is on the signer and the certificate, not the body of the document itself. Question 18. Under North Carolina law, which of the following individuals is a notary public prohibited from notarizing for? A. Their cousin. B. Their spouse. C. Their neighbor. D. Their employer. Answer: B. Their spouse. North Carolina law explicitly prohibits a notary from notarizing the signature of their own spouse. This is considered a direct conflict of interest because the notary is presumed to have a direct beneficial or financial interest in any transaction involving their spouse. While notarizing for other relatives like a cousin or an employer is not strictly forbidden, it is highly discouraged if the notary has any financial stake in the document's subject matter. The rule against notarizing for a spouse is absolute, so that's a line you can never cross. Question 19. A North Carolina notary's journal is considered A. The personal property of the notary, which can be discarded after the commission expires. B. Public record that must be filed with the Register of Deeds annually. C. The property of the notary, but it must be kept for 10 years after the last entry. D. A private record that can only be surrendered in response to a court order or subpoena. Answer: C. The property of the notary, but it must be kept for 10 years after the last entry. While North Carolina law does not mandate that all notaries keep a journal, for those who do, the journal is considered the notary's property. However, it is a crucial record of official acts, and the law requires that if a journal is kept, it must be retained for a period of 10 years after the date of the last notarial act recorded in it. This retention requirement ensures that evidence of the notarization is available for a significant period should any questions arise later. A good way to remember this is to think of your journal as a long-term business record that you must protect for a decade. Question 20. Which of the following is a qualification for becoming a notary public in North Carolina? A. Be at least 21 years of age. B. Be a U.S. citizen. C. Reside or have a regular place of work or business in North Carolina. D. Possess a high school diploma or equivalent. Answer: C. Reside or have a regular place of work or business in North Carolina. A key eligibility requirement to become a North Carolina notary is to either be a legal resident of the state or maintain a regular place of work or business within its borders. This ensures the notary has a tangible connection to the jurisdiction they serve. While an applicant must be at least 18 years old, not 21, and possess a high school diploma or equivalent, being a U.S. citizen is not a requirement as long as the applicant is a legal resident. The residency or place of work rule ensures notaries are accessible and accountable within the state. Question 21. A client asks a notary to make and certify a copy of their North Carolina birth certificate. The notary should: A. Make a photocopy and attach an acknowledgement certificate. B. Refuse the request and explain that notaries cannot certify copies of vital records. C. Direct the client to the Register of Deeds to obtain a certified copy. D. Make a copy and have the client sign a statement attesting it is true, then notarize that statement. Answer: B. Refuse the request and explain that notaries cannot certify copies of vital records. North Carolina notaries are prohibited from certifying copies of publicly recordable documents, such as birth certificates, death certificates, and marriage licenses, which are considered vital records. The official custodian of these records, typically the Register of Deeds or a state vital records office, is the only entity authorized to issue certified copies. A notary's authority to certify a copy is limited to non-recordable documents, where the notary personally makes the copy from an original. Always remember to direct the client to the proper government agency for copies of vital records. Question 22. What is the purpose of the oath or affirmation in a jurat? A. To have the signer confirm their identity to the notary. B. To have the signer acknowledge that they signed the document willingly. C. To have the signer make a solemn promise to a higher power or upon their personal honor that the statements in the document are true. D. To have the signer swear they are legally competent to sign the document. Answer: C. To have the signer make a solemn promise to a higher power or upon their personal honor that the statements in the document are true. The oath or affirmation is the verbal ceremony central to a jurat, where the signer vows that the contents of the document are truthful. An oath is a solemn pledge to a deity or higher power, while an affirmation is an equivalent promise made on one's personal honor without religious reference. This act transforms the document into a sworn statement, carrying legal weight and potential penalties for perjury if found to be false. The key takeaway is that the oath or affirmation is about the truth of the document's contents, not the signer's identity or free will. Question 23. An error is discovered in a completed notarial certificate after the signer has left. The notary should A. Destroy the original document and have the signer execute a new one. B. Use correction fluid to fix the error and initial the change. C. Not attempt to alter the certificate, but instead be prepared to create a new, correct certificate and attach it. D. Resign their commission to avoid liability. Answer: C. Not attempt to alter the certificate, but instead be prepared to create a new, correct certificate and attach it. Once a notarial act is complete and the signer has departed, the notary cannot alter the original notarial certificate, as this could be considered tampering. The proper procedure is to complete a new, correct loose certificate, cross through the incorrect certificate on the document, and attach the new one, noting that it is a correction. This preserves the integrity of the original transaction while ensuring the notarial record is accurate. Never use correction fluid or simply cross out and initial an error on a certificate after the fact, always start fresh with a new one. Question 24. A notary who performs electronic notarizations in North Carolina must A. Use a special electronic seal provided by the Secretary of State. B. Notify the Secretary of State of their intent to perform electronic notarizations and identify the technology they will use. C. Take a separate exam to become an e-notary. D. Only perform electronic notarizations from a registered office location. Answer: B. Notify the Secretary of State of their intent to perform electronic notarizations and identify the technology they will use. Before performing any electronic notarizations, a commissioned North Carolina notary must first register with the Secretary of State. This registration process involves notifying the state of their intention and identifying the specific tamper-evident technology solution or vendor they will use to create their electronic signature and seal. This ensures all e-notarizations meet the state's security and technological standards. The key here is that you must get the state's approval for your chosen technology before you can perform your first electronic notarial act. Question 25. Which of the following is an example of an acceptable form of satisfactory evidence for identifying a signer in North Carolina? A. A signed letter from the signer's pastor attesting to their identity. B. The personal knowledge of the notary. C. A credit card with a photograph. D. An expired U.S. passport. Answer: B. The personal knowledge of the notary. North Carolina law permits a notary to identify a signer based on personal knowledge, which means the notary has a sufficient acquaintance with the individual to be certain of their identity. The other primary method is satisfactory evidence, which includes current, government-issued identification with a photo and signature or the oath of a credible witness. An expired ID, a non-government ID like a photo credit card, or a letter from a friend are not acceptable forms of identification on their own. Personal knowledge is considered the gold standard of identification because it removes any doubt about the signer's identity.